Hello everyone and welcome back to the channel, Ontario Law and the Older Person. And this is Powers of Attorney Part 2, and we're going to look at two court decisions, and this tells us a little bit about how things can play out when you don't pick the right person to make decisions on your behalf. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decision should be made based on this material. Any viewer who needs legal advice should contact a lawyer. This is the first case we're going to look at, Vanier and Vanier, and yes, it's old, but I think it also is an excellent example of what can happen when you're not making the right choices. This is a decision from the Court of Appeal. What this means is that a decision was made, someone doesn't like that decision, so they are appealing to a higher level of court. So the victim of the abuse from her children, Rita Vanier, she was a wealthy widow. Rita gave her daughter, Patricia, continuing power of attorney over property. And as I have there, the decision doesn't say who drafted this document. Was it a lawyer? And that can be a frustrating thing about court decisions. The judges decide what to write down. And sometimes it seems to me they leave out detail that's significant. And I don't have all the information I need to evaluate this judge's decision. Now, if I were that curious, I could go to a courthouse and buy a transcript where I could get every single line, but those cost a fortune, and I'm not that interested. But something to be aware of if you're reading court decisions, is there missing information? Anyways, with this authority, Patricia stole a bunch of money, and Rita had to go to court to have her removed as her attorney. And the decision doesn't say why Rita had to go to court instead of just changing her power of attorney. After the litigation involving Patricia, a settlement amount was to go to Rita. Rita had a new power of attorney, naming her two sons, Raymond and Pierre, as her attorneys. It wasn't long before the two sons started accusing each other of mismanaging her money. So a question, first of all, who drafted that new power of attorney? But also, what kind of relationship did the brothers have before chosen as attorneys? Was there a reason to think beforehand that they didn't really like each other much, or they couldn't work together very well? Or did getting this power make them act in a different way? Because once money gets involved, people can turn into someone completely different. With his authority under the power of attorney, Raymond was able to withhold the funds from Rita. Rita, despite being wealthy, was unable to access her own money and was struggling to pay her bills. So this is a power dynamic that can show up, right? The attorney has access to all these resources. They can find ways to defend themselves and hold on to those resources. The person whose money is being withheld might not be able to get access to it. So how are they supposed to pay for their own lawsuits to try to sue this person to get their control back? This is direct from the court decision. It is paragraph 16. Pierre also urged Rita to make a new, this is continuing power of personal property, removing Raymond so that he, Pierre, as sole power of attorney for property, could instruct counsel to release the settlement funds to Rita. On May 12, 2015, Pierre went to Rita's retirement home to have her execute the 2015 continuing power of attorney for property, which he had prepared following the same wording as an earlier power of attorney. Don't worry about that. Rita executed the document that day. Her signature was witnessed by two staff members at the retirement home where Rita had lived for some time. And this situation has red flags all over the place. So, drafted by the person who would be getting the power under this document. He presented it on the day that she signed it. So she didn't take much time to think about it. It doesn't matter if it's similar to the earlier document, it's still a new document. And, he was telling her, if you don't sign this, you can't get the money. So Pierre might be dodgy, he might not. I just think this isn't a great way to go about it. And why hasn't she learned yet? Maybe her own kids aren't the best choices to be her power of attorney. This is from paragraph 19. In response, Raymond arranged for Rita to undergo a capacity assessment. On May 27, 2015, Louis Silverson, a designated capacity assessor under the Substitute Decisions Act, which we're going to talk about in another video, performed an assessment of Rita. The assessor concluded that Rita was capable of executing and revoking a power of attorney for property pursuant to Section 8, subsection 1 of the STA. Now, the assessor also found that Rita signed the document while subjected to undue influence. And what is undue influence? There isn't a set definition of undue influence. Different sources have different wording, and it can be affected by the context at which undue influence is being examined. But I like the definition from this website. It's from Werefolds LLP, so it's a law firm. Recent trends and obligations when assessing undue influence, and here's who wrote it, and it's from November 2, 2023, and the link to the website is in the description. What is undue influence? In a legal context, undue influence is a finding that an individual's intentions are compromised through coercion and or manipulation, often at the hands of someone in a position of trust or power. Undue influence is more than persuasion. There must be an element of coercion, meaning that if the testator, so in this case someone making a will, could state the circumstances, he or she would say, "This is not my wish, but I must do it." It is not necessary to show physical violence, confinement, or threat. So, undue influence often involves isolating the target from their friends and family. So, Rita has 2 children who have failed her, taken advantage of her, and now we have a third who doesn't seem to be acting quite on the up and up, drafting this document that will benefit him. So, do these circumstances make her vulnerable? Raymond claimed that Pierre had exerted undue influence over Rita and convinced her that if she didn't sign the CPOAP, she wouldn't get any money. He claimed that she wouldn't have signed the new CPOAP if she weren't afraid of being evicted from the retirement home. Okay, except she wasn't getting the money. Raymond was keeping it from her, and fear of being evicted from her home is not at all irrational. This is from paragraph 26, and what I'm showing you here is an example of a judge referring to another judge's decision. So in this case, we're actually reading the appeal of an earlier decision. So this judge, for the appeal, this is what they're doing. Paragraph 26, the motion judge, the judge who made the earlier decision, expressed the view at paragraph 10 that the burden of proof to establish undue influence rests with the party alleging it. So basically, because Raymond is making this accusation, Raymond has to prove the case. The motion judge set out the test for undue influence as follows. The extent of the influence must amount to coercion. Simple influence is not enough. The testator's free will must be overborne. Put another way, it is not improper for any potential beneficiary to attempt to influence the decision of the testator provided the pleading does not amount to coercion and the latter continues to act as a free agent. And I'm not entirely thrilled with this test. I do think it's improper for a beneficiary to attempt to influence the decision. They're trying to press someone else to do something that's in this beneficiary's interest. We're allowed to disagree with judges. The judge found there was no undue influence, that Rita wouldn't get access to her money if Raymond continued to have control over it was basically true. And claiming that Rita was subjected to undue influence was beyond the scope of the assessor's role. So yes, someone is challenging someone else's capacity under a different statute. Assessors have a particular kind of training and there are limits to what they're supposed to do. And this judge is saying determining undue influence wasn't something this assessor was supposed to be talking about. However, we're going to look at a case where the judge kind of disagreed. Not the same judge, different judge. They do that. Paragraph 53. Moreover, far from being immoderate, the 2015 CPOAP conferred little, if any, benefit on Pierre. He was left with the same power as he had had under the 2013 CPOAP. The minor benefit, if one could call it that, is that the 2015 CPOAP protected Pierre from the stress and inconvenience of Raymond's being in a position to interfere with Rita's finances. And to me, this sounds a little snarky from the judge, and I like it when the judges get snarky. It can be fun. However, I don't know the end of this story. There seems to be no more reported cases. Sometimes there are court decisions that never get reported. Sometimes nothing more happens. There are no more court decisions at all. But did Pierre act like his siblings and screw Rita over as well? Uh, did she have other unreliable children to contact? Did she get a lawyer to properly draft this paperwork? No idea. Moving on to the second case, Luiki and Bascus. I'm not sure I'm pronouncing that correctly. A al. And when there's an A al there, it means there's more than one individual or organization involved. And this is from 2025, the Superior Court of Justice of Ontario. Lionel Bascus is 94 years old. He has two daughters, Del Lewicki and Joy Bascus. He has over $3 million in assets, including a condo. It was understood that he would be splitting his estate equally between his daughters. Lionel has significant health issues, including severe neurocognitive impairment and paranoid ideation, and that is an exact phrase from the court case in paragraph 3. In time, this paranoia would involve the belief that his children were stealing from him. Just a warning, for some reason, I can't say Lionel's name properly. My tongue just doesn't curl the right way. So yeah, you can laugh at me every time I mangle it. Anyway, so prior to this court case, Lionel's wife died and his sister, Gerda Bascus, returned to his life after over 40 years of estrangement. After that event, Lionel signed new powers of attorney that granted authority to Gerda as well as transferring the condo to her. So yeah, someone swooping in immediately after the most likely heir has died. Yeah, red flags all over the place. And this case involves Dell, his daughter, challenging these decisions. The questions being determined were, did Lionel have the capacity to understand and sign these new documents? Was he acting as a result of undue influence from Gerda? When challenging the validity of such documents like powers of attorney, the challenger has to demonstrate suspicious circumstances, and questions to be asked include, what was the context involving the creation of the documents? Context might include who drafted the document, who benefits from it, and were the documents signed in a rush? Is there a reason to believe the signer of the documents lacked capacity? So while we're supposed to assume someone has capacity, are there warning signs that they might not have it? Can they not understand the document? Can they not describe what the document does? And then was there evidence that someone else was trying to overwhelm the signer to the point that the signer is making decisions they normally wouldn't? So signs someone might be trying to, have undue influence is insisting on being in all conversations, like with the lawyer, uh, insisting on being part of the conversation and prompting the signer to give certain answers to certain questions. If the challenger can bring sufficient evidence on these circumstances, the burden of proof shifts to the defender of the documents to prove everything was on the up and up. Gerda failed to meet this burden, so she couldn't prove that these documents were done legitimately, so she lost and had to pay Dell $135,000 in legal fees. This is a pretty insane amount of money. Litigation is expensive, but if you were to read the case on canley.org, you could see that Gerda also messed around with the court proceedings to make it more complicated than they needed to be. Also, if you were to read the case, you would see that $135,000 is pretty close to what Dell actually had to pay. In most cases, even when the person wins and they get an order of costs to be paid to them, they don't get nearly as much as what they actually spent for this process. I don't know why, but that they got so close to the amount that they'd been looking for, maybe the judge was a little ticked off. From paragraph 8 of the court decision, after Gwen's death, Gerda convinced her brother that Dell was stealing from him and trying to sell his condo. In December 2023, she changed the locks on the condo. Gerda claimed this was done on Lionel's instructions and attempted to move Lionel's assets to a new financial advisor. So red flag, red flag, red flag. On January 9th, 2024, Lionel transferred the Belvedere condo to Gerda and made the new POAs, naming Gerda as his sole POA for property and personal care. And again, red flags, including that very tight timeline. That's a lot of big decisions made in a very short period of time. Lionel's capacity was assessed 3 times: on June 23, 2023, January 16, 2024, and November 7, 2024. While the first assessment concluded that Lionel did have the capacity to make the documents he did, the latter two didn't. And Gerda denied the severity of his poor health. And yeah, that's a pretty tight timeline, but I'm sure we all know of situations where someone was, you know, determined to have dementia, yet still able to make all the decision and operate pretty well. And then it's very quick to where they are no longer trusting people around them and no longer able to make good decisions. A lawyer drafted the documents. He met with Lionel only twice combined, representing 1 hour. Gerda attended these meetings. The judge found the lawyer's services inadequate in multiple ways, including, and by the way, you can get the name of the lawyer if you want to go to the Canley website and read the case for yourself, but I'm not putting it here. Anyways, the lawyer didn't see Lionel's ID, and that is absolutely wild. Anyone could be pretending to be Lionel and signing these very powerful documents. Like, this is crazy. The lawyer's notes of the meeting were deemed insufficient. Lawyers are expected to keep detailed notes. This is not just to meet standards of competence. It's also because, hey, you might end up in a trial and you might have to justify your actions and you might have to offer your notes. And maybe your notes shouldn't be so bad that the judge refers to them as being scribbled. The lawyer failed to ask questions about Lionel's health, his understanding of his finances, and the repercussions of his decisions, or why he was giving his condo to Gurdon. Now, here's the thing. A lawyer isn't supposed to just mindlessly put down what the client says in legalese. They're supposed to be sure that the person understands what they're doing and warn them of possible repercussions. And then, if you do A, B could be the result. Do you know that? Are you willing to accept the consequences for that? And it sounds like the lawyer didn't do anything like this. Straight from paragraph 13, he accepted a joint retainer to act for both Lionel and Gerda on the transfer of the condo, right? So this is an asset, and did not advise Lionel to receive independent legal advice because it would have delayed the transaction. No, you don't cut corners. Why is time even an issue in this particular situation? And not only is this dicey in general, it will make the document more vulnerable to challenges. Every time you skip a step, every time you fail to do an important thing, it leaves that document up to attack. So this is just bad idea after bad idea. The judge found the lawyer's poor behavior extended into the trial. So during the trial, the lawyer was a jerk in the witness stand. Yes, the demeanor of a witness will be part of evaluating the testimony the witness gives. And too many people think they're being clever when in fact they're just being obnoxious. And that impresses no one, and it's not a good risk to take. The lawyer was disrespectful to the lawyer cross-examining him. Lawyers are expected to treat each other with common courtesy. And so this lack of professionalism in the trial would support a perception that the lawyer was unprofessional when dealing with his client. The lawyer was evasive. Don't plead the Fifth Amendment in court. We don't have one. There was a geriatric appointment involving Dell, Lionel, and Gerda. Gerda's behavior was extreme, aggressive, and caught on camera. She called both Dell and Lionel idiots, told Lionel that Dell was after his money and had attempted to sell his condo. She also claimed that Dell had bugged their phones. So the judge's decision doesn't state that anyone bugged anyone's phone, and there was no evidence that Dell had tried to sell the condo. So here we're seeing indicators that Gerda is unsuitable as a power of attorney beyond seeking financial gain. She overreacts to challenges. If she's willing to denigrate Lionel in front of witnesses, what is she like behind closed doors? And the claim that Dell bugged her phones and tried to sell the condo could be lying, could be signs of her own version of paranoia. Evidence provided by Gerda's son, Graham, included that she had been involuntarily admitted into hospitals due to, among other things, paranoid delusions. These delusions included the belief that her landlord was injecting noxious gas into her apartment and hired neighbors to hit her with radiation. So, yeah, huge signs. And also, if you ever want to find some interesting information about people who think this way, look up gang stalking. It's a very interesting and sad phenomenon. Anyways, Graham also confirmed that his mother had been absent from Lionel's life before Lionel's wife died. The judge found the circumstances were suspicious. The judge believed there had been a lengthy estrangement. The abrupt change to giving the condo to Gerda was odd, though using judge speak for that. The lawyer had done an inadequate job. Continuing with that list, Lionel lacked capacity. The accusations against Lionel's children were unfounded. Gerda's evidence was unconvincing and she hadn't rebutted the claim of undue influence. So, rebutted, basically, as I mentioned, initially burden of proof on the kids fighting these transfers. They proved suspicious circumstances. Now it's Gerda's responsibility to disprove that the circumstances were suspicious, that everything was on the up and up, and she failed to do so. And then we're moving on to a paragraph in which, once again, a judge is referring to a court decision someone else made. Now, in this case, it's not in the same piece of litigation with the same parties, completely different parties. Judges do this, they borrow from each other all the time. So, paragraph 62. In examining the evidence with respect to undue influence in the case of that court decision's name, don't need to know it, the court listed several factors which are often considered. These considerations include evidence of the following, and here we're going to be talking a bit about undue influence where the wording is different. A, dependency on the beneficiary for emotional and physical needs. B, social isolation. C, recent family conflict. And D, a change inconsistent with previous estate planning. And I think we can see all of that was happening with Lionel. And here at paragraph 63, we see another example of this judge referring to another court decision. So from that paragraph, other evidence that may support the presumption of undue influence includes pre-death transfers of wealth using a lawyer previously unknown to the testator, the respondent, in this case Gerda, giving instructions to the lawyer, and then a bit more stuff that I've cut out, but I think all of those factors are also at play here. The judge also felt Gerda wasn't a good choice as an attorney for the following reasons. Her acceptance of the condo was a breach of her duties under a power of attorney. She's supposed to be representing Lionel's best interests, not her own. There was evidence she wasn't taking proper care of Lionel's health needs. Her own unaddressed mental health issues. Her belief that the children were plotting to steal from Lionel was reinforcing Lionel's belief of the same. So she was creating a kind of echo chamber that it would be difficult for Lionel to be able to escape from. The judge ordered that the powers of attorneys in Gerda's favor be put aside, and the earlier one, identifying Dell as the attorney, be resurrected. The transfer of the condo was voided and the condo returned back to Lionel. And so, happy ending, right? Well, is it? Because Lionel now doesn't trust Dell. He does not want her having control over his life in this way. So even though he lacks the capacity to make choices, is it right to put him in a state where he is emotional, resentful, doubting? Doesn't that matter too? Now, I don't know what the solution to that issue is, but just because he lacks capacity doesn't mean his wishes should be ignored altogether. Anyways, so that's the end of this video. Thanks for getting to the end. Have a great day.